My spouse withdrew my I-751. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. The other day on the Immigration Answer Show, an immigrant, told me that their spouse, their wife, had withdrawn their I-751. So, of course, if you have been watching my channel for a while, you know that people who get a marriage-based green card and whose marriages are less than 2 years old at the time that the green card is approved and issued, that they have to file a form called an I-751, which is a petition for removal of conditions. They have to get the conditions on their lawful permanent resident status lifted so that then they become truly permanent residents in the United States. It's one of the ways USCIS cuts down on marriage fraud, immigration fraud, is they want to see the length of time together. And so they'll give you that initial 2-year green card, but then at the end of those 2 years, you have to file the I-751 to get those conditions removed, and then you're going to have that 10-year green card. So typically, in 99% of the cases, these cases are filed jointly. And the U.S. citizen or green card holder spouse signs it, and then the person who received the green card signs it. It's filed jointly. We call those joint 751s in our office, and that's where everything's fine with the marriage. The couple's still together. They have lots of evidence, and they're filing their application together. Then we have what we call I-751 solos, which is for people who have gone through a divorce or they're seeking some kind of waiver because the spouse was abusive or for some other reason. They're filing it without their spouse, and that's a solo case. So on this video, we're talking about what my caller mentioned, which was that they had a jointly filed I-751. It had been pending for about 1.5 years, 2 years, and the couple was living apart because the beneficiary had taken a job out of town, and according to the beneficiary, his spouse had divorced him by publishing a notice in the newspaper of the court proceedings. In other words, he was not personally served. The spouse went with notification by publication, which may or may not have been a sneaky trick to keep him from being able to contest the divorce. But because he was living in another state, he didn't get notice of that. Now, I think the divorce attorney for the U.S. citizen is required to make a good faith effort to notify him even beyond publication. But long and the short of it is, according to the caller, he didn't know that his wife had filed for divorce, and he just found out that his wife had filed to remove her endorsement on the 751. In other words, she asked USCIS to withdraw the I-751 that had been filed jointly, and actually she has the right to do that. Now, it was really surprising. I haven't had a scenario like that. I've had people withdraw the I-130 before without telling their spouse, but I don't think I've had one where somebody unilaterally withdrew the I-751 and the beneficiary didn't really have a clue. But according to this caller, that is what happened to him, and he wanted to know, what do I do? Well, here's what you do when that happens. You need to get a new I-751 solo on file as quickly as possible. You can still stay in the United States, and you can still get a 10-year green card and eventually become a citizen, but it becomes a much harder road to hoe. And really, that time period between when they file for divorce and when they withdraw it and then you're refiling, that's a real tricky time period, because technically you're on the road to being out of status. You could get served with a notice to appear in immigration court. You could be on a path towards deportation. We don't want that to happen, so we want to get an I-751 on file as quickly as possible. In fact, in that scenario, I would probably work towards filing a very fast case as opposed to a very thorough case. I would, generally we want to submit as much evidence that we can that the marriage was real, and that's, of course, on an I-751 solo, what you're going to have to prove that the underlying original marriage was valid. But in this situation, you want to get that thing on file as fast as possible and then supplement it at a later date. But, depending on how much evidence you have, how much new evidence you have, what kind of a history the couple has. Of course, if they were living apart, that's going to be problematic. But at the end of the day, you want to get that new 751 on file, and then you want to make it as strong as possible. If you can do both at the same time, that's better. But if you can't, at least get the new 751 on file so USCIS sends you that extension letter, they know who you are, and they can begin processing your case, because, as you know, 751s are taking years and years right now. So the important thing is get that bad boy on file and then go from there. I hope this makes sense. If you find yourself wanting to file an I-751, whether it's jointly or solo, and you need our help, we'd be happy to help with this. This is what we do every single day. You can reach us at 314-961-8200. You can email us info@hackingimmigrationlaw.com. We also have some free resources for you. If you're not looking to hire an attorney, you can find us on Facebook in the Immigrant Home Facebook group, or you can find us on YouTube by just looking for us there. We're also on TikTok at Immigration Hacking. And then finally, We have our Immigration Answer Show where I go live 3 or 4 times a week trying to answer as many immigration related questions as I can in just 1 hour. We'd love to see you anywhere and everywhere. Thanks so much for connecting, and we'll see you next time.